Cool. So we're really excited to be here today for our social media and the law with Heaney Partners. And we've got the amazing Simone who will be kicking off today and asking all your intense and exciting questions. Thanks everyone for joining us. Simone, it's all yours.
Well, hi and welcome to welcome everybody to our NZARH chat with Heaney Partners. We're so grateful to Corbin, Shyrelle and Kent for being here with us as we go through some of our questions that our industry needs some clarification on. As Pip said, I'm Simone and I'm on the executive board for the NZARH, and Pip is going to help me record this so we can go over some bits and refer to it or get other hairdressers to have a look into it later on. We've been working with Heaney Partners to upgrade our best practice guide, and this is a great tool that all salons should have one in their back room so that they can refer to any times of needs. It covers things like costing out a service, so you know exactly how much your costs are for the salon, to how much you need to charge to cover all those costs. It goes over taxation, it goes over employment, recruitment, training and education, and all sorts of templates are in there to help you out. We were just talking before that there's going to be some new privacy changes, so when they come up, you know, all of that will be in this best practice guide that we feel would be a great tool for most salons to have. So this has been a really strange and hard year for most of us. So when legal problems arise, we need to know that we've got someone that we can turn to for help. So NZARH has got your back, and we offer all members a free half-hour talk with our lawyers, Heaney Partners. So let's get on to those burning questions. So the first question we have for you guys is that this, as a salon owner, I have had a staff member take intellectual information from my business and now cannot afford to pursue this. What would you suggest? So I think this is something that happens to a lot of businesses when they have particularly software systems that have all our clients' details and that in it, that we do tend to share with all of our staff. And when they've taken that, obviously when they've left that salon, they've taken all that information with them. So what does somebody do in a situation like that?
Okay, so obviously this is a very serious problem, and certainly in our experience, intellectual property theft leads to some pretty significant business losses financially, in terms of reputation, and just in terms of branding as well. I mean, the effect can be that somebody takes your business idea and attempts to convert it to their own. There are really two approaches. The first is around mitigation and trying to prevent that problem from occurring in the first place. And then the second approach that we'll talk about is what you can do to punish that person or to take action, and that can involve litigation, which we'll talk about. In terms of the first approach and trying to mitigate this problem from happening in the first place, the question talks about staff members specifically. So we assume that there's an employment relationship in place, and typically the employment relationship is governed by intellectual property provisions, confidentiality provisions, and restraints of trade. Those are the three categories of clauses that we usually see in the employment agreement. And the idea behind those provisions is to really protect all of the important information that a business has, but that it also needs to share with its staff in order to carry out work. So we want to be able to share that information in a safe way, but prevent those staff members from disclosing secrets and other important details to third parties, or in fact using it themselves, misusing the information to compete with the business. Now, those provisions, that's the intellectual property, the confidentiality, and the restraint of trade provisions, they all survive well after an employment relationship ends, which is helpful, right? Because in this scenario, we have a staff member that leaves and takes trade secrets with them. And the Employment Relations Authority, which is our main forum for dealing with employment disputes, enables an employer to go away and to bring an action for breach of those clauses. So the starting point is to set yourself up well to be able to protect yourself in the event that this happens. But mitigation goes further than that. It's about communicating with your staff and making sure that they are aware of these provisions, the protections that you have in place, and that they know that when the employment relationship comes to an end, they're not to use any of your important information or try and compete against you. And so it might be that you have a discussion with staff members every year or so, or around the time that somebody is expecting to leave the business. It might be that you have written workplace policies that really set out in detail this kind of scenario and the kind of action that you would expect to take if a staff member did take your intellectual property. So yeah, that's good practice, and you'll hear us talking about that sort of mitigation as we go through the seminar. It's all about trying to anticipate these risks right at the beginning so that you can save yourself a whole lot of hurt and frustration later on. The second approach that I wanted to talk about is, well, what happens when, in spite of all of these protections you've put in place, you still have a rogue staff member who misbehaves and causes a lot of strife for your business. As I said, the Employment Relations Authority can look into these types of matters, and they do treat them very seriously. We have been involved in cases where employees have been penalised. Penalties can be significant, and they obviously range, but they can get up to as high as $50,000. And so you can really see that the authority is looking to send a clear message to employees who know about the restrictions on their ability to use your information, but disregard those and decide to cause problems anyway. Again, this is a common theme that you'll hear through the seminar. While you can bring a complaint, there are some downsides. Obviously, there's some expenses, legal costs to factor in, and it's not a very nice process to have to get involved in litigation, which I think places even more of an emphasis on really trying to anticipate these problems up front.
So what often we can recommend too, and we can probably help with this in terms of that half-hour free legal service we provide, is often what's a good start is a telephone call or an email, setting out your complaint against their former employer, so setting out what you perceive that they've done wrong, and then reminding them of their obligations under their employment agreement or former employment agreement, and what steps you can take to make sure to prevent them from continuing with that behaviour. And that often, I would have said, Corbin, probably maybe 80% of the time, perhaps that might be a little high, but more often than not, that is actually enough to stop them in their tracks and prevent them from maintaining the behaviour. So first instance, you might be able to actually, shut it all down by some very clear, robust communications. And we certainly, in fact, I think we've helped out perhaps a number of people that way. And hopefully that does get rid of it. So don't feel that you've got no sort of power except to go to the ERA. That really is a very good resource, but that's the end, that's the end of the job. Often if you provide a very robust and detailed piece of correspondence, when you find out about the behaviour, that can be enough to remind the person of her or his obligations and to shut it down. So
that's awesome. That's so good, because I think one of the biggest things for hairdressers is that we write down colour notes and stuff, and we're scared that our staff is going to take it to another salon. But I think the what you said before is making sure that we have meetings with our staff, have clear expectations, have it all written down, and have them sign what you've talked about so that they do understand. I think sometimes in salons we're so busy that we forget about having our team meetings and reminding people of the right behavior. So like a little bit different to corporate where you're talking about those sorts of things all the time. Our industry is so focused on the creative side that we do forget about the business side, and the business side is so important because when these sorts of things happen, everyone's like, oh my God, this shouldn't have happened and they're doing this. But if we'd had those clear discussions in the first place, it certainly would make things so much easier.
Definitely. And I think to giving, as Corbin said, those clear examples, it's all very well to talk about the principle of what they're not supposed to do, but they get into the nitty-gritty. This means don't do this and don't do that. So they can, they're really clear on what the expectations are. And I think too, I don't know how often you do exit type interviews, but I think again, Corbin raised, that's a really good time to remind them that just because you're leaving a salon, that doesn't mean all those sort of obligations suddenly go away.
Yeah, definitely. Yeah. The other thing I was going to just mention is that there is most salons these days use some sort of software program, whether it be Katumba or Timely or whatever, and they do have admin type, I don't know what you call them, where you can turn certain parts off to the staff so that they can't get into everything that's sort of on your system. So I think that would be a timely reminder to make sure that you have got your settings on your computer how you want them.
That's right, and particularly when you have a staff member leaving, because I think all of us operate in this bubble where our staff are by and large happy from day to day, but you do often get a situation where a staff member is about to leave and perhaps they become aggrieved or for whatever reason they decide that it's worthwhile for them to take some of the business information or try and do some damage as they go out the door. And so it's really important that you have taken the right steps to prevent access or really just limit the amount of damage they can do if you find yourself in that scenario where they're unhappy and you think there's a risk they might do some damage.
Yeah. No, I think that's really awesome, and I hope that's really helped with this person that's going through that. Our next question is probably along the similar thread. It's when a staff member leaves the salon and works somewhere else, can they use the photos of the work they have done in your salon that appears on your social media to promote themselves at their new salon? Who owns the photos on social media?
Right. Well, I think the starting point, and correct me if I'm wrong, is that once they're out there, they're owned by the social media network or outlet. So I think that's the starting point.
Yeah, that's right. So I think, we need to start with a big warning that says social media is great. It's obviously a great advertising platform for salons, particularly small salons with limited budgets. But the trade-off anytime you're not paying for that sort of advertising is that you're losing something, or in this case, you're losing ownership rights over the content. That's how the social media platform makes their money. So you need to be prepared to lose control over whatever that content is when you hit the submit button. And that gives rise to a lot of problems, some of which have been raised in this question, so that's great. Let's start with the perhaps easier question is around privacy laws, and when you're, for example, posting a photograph of a client, that's a person who's come to your business, they're providing you with personal information, in this case, a photograph of themselves, which identifies them. And you need to be really clear with them that when you hit submit on the post, that photograph will go to the world at large. And there'll be a couple of implications. The first is that you won't be able to retract that content very easily. So things like deletion or correction to that personal information become quite difficult. And the Privacy Act requires that you make best efforts to make corrections to personal information or in fact remove it if that's what you're asked to do. So you need to be clear with this person that that's going to be difficult. The second component component to have a think about is that other people can use that content however they wish. So while you might have consent from that person to be used in your particular salon's branding, you have no real control over what other people might do. They might, for example, turn that person into a meme, and the person might object to that. So our advice is that when you're getting consent, it needs to be very wide reaching in terms of its scope and what you're permitted to do with the information. So that's the privacy implications. I think just to directly answer the question, who owns the photos on social media? Well, social media platform technically does. And I think sort of what's inferred in that question is, does the salon have any rights? Can they claim ownership, or can they try and pull down a post that might have been submitted by somebody else simply because they created the content in the first place? Well, the answer is there's nothing to prevent you from making a claim, and there are certain avenues that you can go through with large social media platforms where you can submit a inquiry or make a complaint. But what we are seeing is that with these very onerous terms of service that most social media companies have, it's very difficult for you to try and claw back that content. So just be aware of that. Then the other element to this question is around the end of an employment relationship here, and staff effectively using all of your goodwill and using the training that you've provided and the content that you've created, and taking advantage of it later on, and perhaps with one of your competitors. And so that's obviously a problem, because you know, that other salon might be competing with you directly. Again, it may be difficult for you to prevent the other salon or the ex-employee from using that content. For practical reasons, you know, it might be difficult for you to take back copies of photographs and videos that might have been taken in your salon. One thing you can do, which is a practical solution, is watermark the content. You might be familiar with that practice, but essentially it's putting some sort of branding or identification message on top of the photograph. And for 90% of the population, that would be sufficient, because those people don't know how to remove the watermark. And so your branding will carry through with whatever content is being posted, particularly on social media. So that's a suggestion, but legally it is difficult to prevent your ex-staff and your competitors from using that content. I think really our advice is consistent with what Shyrelle was saying earlier, which is that nothing prevents you from writing to these parties and trying to encourage them to correct their behaviour, and making them aware that it is your intellectual property, it's your copyright that they may be infringing on, and that you require them to stop. And of course, if they don't listen to that, then you have more formal legal recourse, and we would help you with that.
I think you guys probably know that the new Privacy Act, I think it comes in December this year, December 2020. And we've had a review of it. It's a reasonably there are some reasonably significant changes to it, but I think it's fair to say that the principles that we are familiar with in the old Privacy Act remain in the new Privacy Act. If anything, just the way that we're going to, and those principles are going to be enforced, is slightly more onerous. So in terms of the best practice guide that we're helping the NZARH with, we will need to tighten that up a little bit to reflect the changes. So that will end up being a very updated and helpful guide to the members, I hope. But there's still a bit of work to be done around the changes before we finalise or fully understand all of the implications. But I think in the meantime, until December 2020, obviously we've got the old Act, and I think the message is that just keep behaving in the same way, because the principles are the same. but we'll get some updated guidelines out there very shortly so that everyone is aware of what changes there are.
Yeah. So with taking photos in the salon, should all salon members be getting a written signature to say that those clients don't mind having their photo taken and put on social media, or once they agree to having their photo taken? Because normally most of us have ring lights now that we take, once we finish their amazing color, we take them over to the ring light area and take their photo. Is that permission enough that they have given us to put it on social media, that they're agreeing to have their photo taken? Or should we be getting written?
Yeah, it is, in principle, it's probably enough. I mean, consent is consent. What the issue arises is proving the consent and the scope of the consent. If there's a change of mind by the client, suddenly they're not so happy with the fact that it's been posted. So for that reason, our recommendation would always be to get it in writing if you can, because then you've got the piece of paper, it's got the scope of the consent hopefully detailed. It doesn't have to be a whole lot of detail, but just generally what's been agreed, because otherwise it becomes a she said versus he said, all about credibility, and it's very difficult without that written piece of paper. So we always recommend it in writing.
Okay.
One thing we could also do is prepare a very short template, which has I, space, insert the person's name, have agreed on this date to allow my photograph to be put on social media. So the association has a template that it can just have a few copies sitting at the front desk, and if a client wants to have their or authorises their photo to be on social media, you just fill in the blanks and then save it.
Yeah.
Could be another way that we could help you, get that written consent so it's not onerous on you.
That's right. And best practice, really, particularly if you're concerned about this, is to have a privacy policy in place. A lot of organisations have that made available on their website. So just a link that you can go to. It doesn't need to be a long document. It can be a half a page that sets out how any personal information that the salon collects can be used, and that would include photographs. You might want to back that document up with the kind of express consent template form that Kent's talking about. And that way, if there is a problem down the track, then you can point to the various forms of consent, both implied consent through the privacy policy and also the more express document that a person might have signed.
Yeah. Yeah, no, that sounds really good. I mean, I would hope that if it was a client that didn't want their photo taken up, that a salon owner would just take it down, because usually it's of our very best work, and if they don't want it up, then it's up to the salon owner to do the right thing and take that down. What other sort of policies, having that privacy policy on your website sounds like a great idea, and that's something that maybe we could work towards to getting a template for that as well. What other things should we be aware of with this new Privacy Act that's coming in? I mean, we have sort of like the golden rule that we don't talk about other clients or staff to either as clients or staff. What other things should we be aware of with this coming out?
And it's such a wholesale change. I wouldn't like at this stage to highlight any particular issues, because if we identify one main one, we might be leaving out others. So I think if I could just say, we will get something out there to circulate very shortly, and certainly before December 2020, so that everyone is fully informed. So I think the best practice at the moment is just to proceed on a very cautionary basis. And we all know what information we'd expect to keep private, what we'd expect to be asked to consent in terms of delivering to the wider public. So I think just proceed along the lines we have been under the old Act, but we will get something detailed out there very shortly so that people have a thorough understanding of the changes.
We have reviewed the privacy bill, which is the form that the legislation sits in at the moment. Very generally, I think we can say that it's going to affect organisations that manage a great deal of personal information the most. So that might be social media companies based in New Zealand, and larger organisations, certainly larger than most of the salons that form part of your membership. it's going to place more of a focus on companies complying with the Act rather than individuals, which is something to be aware of. And then there may be enforcement powers against companies and quite significant financial consequences if your employees have breached the privacy principles. And the other thing I think we need to note is that the Privacy Commissioner, which is the enforcement body under the Act, should have stronger powers to investigate complaints. And so that might mean that there's a bit of an uptick in the number of complaints coming through, and you need to be wary that once the Commissioner is involved, then they might be scouring through your records and really doing a detailed look at your privacy practices.
I mean, as a consumer, that sounds like the average person would feel a bit safer when you're putting your details down everywhere you go now. You have to put your details down for everything. So, I mean, as a consumer, that sounds like it would make you feel a little bit more comfortable that your details were out there but weren't going to be used for something that you hadn't sort of signed up for.
Yeah, that's a good point, yes.
Yeah, that's good. That's probably the end of the questions that I had. Was there anything that you guys have got that would help anybody with the COVID thing? You know, is there any sort of questions that we should be aware of, or things that we should be aware of now that we're back into working full time?
I mean, it's interesting because we've obviously got various levels still throughout the country with COVID. There's Auckland's still on level 2. Probably.
Yay!
And everyone else on level 1. And we did have a discussion about this before. And I mean, I'm sure all the salons are right up to speed in terms of making sure they have, you know, people are scanning in terms of contact tracing or signing in, that there are obviously sanitizer everywhere. The question of wearing masks is interesting. I don't know whether the level 1 salons are using masks. There's a variety in Auckland. I think some are still wearing masks and some aren't. But obviously, I think we need to think about what's something for actually the, you know, not only our staff or your staff's well-being in terms of taking the precautions of mask wearing and or social distancing, but also the client who might be particularly vulnerable, we might not know. So I think just continuing with a very sensible approach to that, notwithstanding what the levels are really, just that the virus is out there and we all need to maintain sort of you know, be very careful about our behaviours. I don't think there's anything else on COVID that was coming up.
I suppose just a reminder that contract tracing is still really important, and you know, it would be helpful to remind your clients that they should be checking into your salon regularly, just so that if anything was to happen, that you have good records, or at least the Ministry of Health has good records of where your clients have been.
Yeah.
Yeah, we at NZARH still recommend that any salon in level 2 that both the salon, sorry, the staff and the clients are wearing masks. We're in Auckland, so our salon's still doing that, and we've only had one person that we've actually turned away because she wouldn't wear a mask. So, you know, as soon as you explain to your clients that we're doing it to keep them safe, we haven't had any problem. In fact, most people have come in with their own mask. We do have some disposables or that people can use, or they're running back to their car. Oh yes, I forgot, I'll get my mask. So I think it's been, the hairdressers in particular have been really onto it. We're doing the contact tracing, we're making our clients wear the mask, and our sort of attitude is that if we have to do this to get down to level 1 and to stay open, we're prepared to do that. And our clients are very grateful and thankful that we're keeping them safe. So I think most hairdressers that are in level 2 still are wearing masks.
Great, yeah. Oh, that's excellent. I think, yeah, we just have to set example, don't we? Lead by example, really.
Yeah.
That's the best thing. Yeah.
Right. And we know that COVID has put a lot of pressure on small salons, and you know, there's financial pressure. There's also you know, your desire to keep business going, and you may even get to a point where you need to start restructuring or taking steps that are going to affect your staff. We've been fielding a lot of calls about employment-related problems because of those stresses that are in place. I suppose it's just a reminder that the 30-minute free phone call is available to members, and they're welcome to give us a call if they are facing those sorts of difficulties.
Yeah, and it would be definitely recommended to call you guys before they started doing anything themselves, because as we all know, there's so much that is involved in restructuring, or if you're planning to downsize some of your team, we don't want anyone sort of falling in between the cracks for that sort of thing. We really need to have that more lawyer background to help our members out.
Yeah, we like to think it is helpful. I mean, it is a process, and when you're embroiled in it yourself, sometimes you're not giving it not as careful thought, but things aren't as clear as they might be. And what we hope we do is provide an objective sort of position, and also just remind everyone of their obligations as employers, so that they don't fall foul of any of those rather strict guidelines.
Yeah, that's awesome. Pip, is there anything else that you have got any questions from?
Nothing at this stage, although we will be sending out a little survey after this video when it's been downloaded, and we'll send that link out to everyone to rewatch. And there'll be a little survey asking for some questions in there if people still have thought about something afterwards. So we'll certainly get onto that when they come in.
That's good. We'll be happy to answer them afterwards. So that sounds good.
Awesome.
That's awesome. Okay, well, if there is no other questions, I would just like to thank Corbin, Shyrelle and Kent. That has been amazing for you guys to spend some time with us this morning. We really do appreciate it, and I'm sure once our members sort of watch this, and it's going to remind them of employer obligations, how to have meetings, and making sure that we are keeping in contact with all our team all of the time, because I mean, most of us have been back at work and we've had to work 70-hour weeks to catch up with everything. It's a great reminder that we must keep in contact with our team. I mean, we see them all day, but we don't actually, hairdressers don't often sit down and actually chat with them. We're sort of like, hi, bye, and everyone's carrying on working. So it's a great reminder to everybody to just have those chats, have those talks. And I mean, once you've had those talks, you may find that your staff is happier than what you thought they were, or if they have got a problem, at least you can get it sorted straight away. But thank you guys so much. Thank you from myself and from Pip and from the NZARH. Really do appreciate your time.
Always good at any time. Look forward to those follow-up questions.
Awesome. Thank you so much.
See you.
Thanks,
Bye.
guys.
Bye.
Awesome. Thank you, everyone.
Thank
Bye.
you. Bye-bye.